right, everybody. Good evening. I just left it a few minutes so that people could make their way across that huge, vast hall to get here. It takes about 20 minutes, doesn't it? You're very welcome, and I'm very pleased to see so many people here and such a distinguished audience. I'm Frances Crook. I'm the Chief Executive of the Howard League for Penal Reform, and I'm going to chair this evening's meeting, seminar, conference, discussion, lecture. My first, I do have to do, housekeeping stuff. It says here, please switch off all mobiles and Blackberries because it interferes with the sound equipment. That's very optimistic, I think. And the fire alarm is a message over the tannoy system. Please follow any guidance given. I won't be giving any guidance. Somebody else will do that. And when instructed to evacuate, the fire exits are, and it says here, point to the two entrances you just came through. And then I will then direct you to the correct assembly point. Well, actually, I won't because I don't know where it is, but I'm sure we won't need that. Touching wood here. This evening is a lecture held in memory of Milo, Lord Parmoor, who was a great supporter of our work. And I was particularly pleased that we were able to set this lecture series up while he was still alive and that he came to some of them. I told him that we were going to continue them. And he was very generously left us a big legacy. And both his memory and his money is put to work. And this lecture is to celebrate his life and to celebrate that generosity. And I want my second task of the evening is to remind those few of you who are not members and regular donors to the Howard League that you should be, and that we will not let you leave until you have filled in a membership form, because we do rely on your support. We're gathering a lot of members. We've had 1,000 new members in the last few months, which is fantastic, but that gives us authority, credibility, a reach into different places. And so it's incredibly important for us that you do join and become part of the Howard League family. Now, my real task this evening gives me great pleasure. It was my idea to ask you, Peter, and I'm very, very pleased that you've agreed to talk to us this evening. His Honour Judge Peter Thornton QC is the new Chief Coroner, and our first Chief Coroner. But he has an illustrious and very distinguished, eminent legal career in the past. As the Assistant Deputy Coroner, he did the inquest for Ian Tomlinson. He's been a senior circuit judge at the Old Bailey. He was joint head of Doughty Street Chambers and founded Doughty Street Chambers. And, of course, most importantly of all, he was for many years a trustee of the Howard League for Penal Reform and one of my bosses. So I'm really, really pleased that he came this evening to talk to us, and I'm really looking forward to what he has to say. Peter.
Thank you very much, Frances. Is the sound reasonably good? Yes. Well, it is a real honour and a pleasure to be invited to speak today. The Howard League for Penal Reform is one of the great reforming charities of our time. As the oldest penal reform organisation in the world, its work since its inception in 1866 as the Howard Association has been outstanding, challenging government after government to make humanitarian changes. Some of its recent work on children in prison, women in prison, suicide and self-harm and restraint has been truly inspirational. Thanks, no doubt, to the indefatigable and formidable talents of its director, Frances Crook, and her team. John Howard, the penal reformer, was drawn into the world of prisons in his 50s, in 1773, in his year of office as Sheriff of Bedford. He discovered that prisoners who had been acquitted at the assize courts were taken back to prison and kept there, simply because they could not afford the fees of the jailer and the tipstaff who had held them in custody in the first place. Howard requested that this injustice should be avoided, by paying the jailer a salary, but the counties resisted the extra expense. And John Howard spent the next 17 years, as he said, looking into the prisons where I beheld scenes of calamity, which I grew daily more and more anxious to alleviate. He made many prison visits, and he survived the plague, jail fever, and much more. And he said he survived them because he was a vegetarian and a teetotaler. I hope there will...
Obviously, we all follow that.
Yes, well, thank you. Well, I was proud to be a trustee until recently of the Howard League, when the board decided that I should go, so that they had the opportunity, if necessary, to challenge my work as chief coroner. I look forward to some robust criticism to keep me on my toes. I still have the pleasure of chairing the Howard League Lawyers Network Group. I only met Lord Parmoor once in Holloway Prison in a canteen, as one does. We were on a Howard League visit, and we had a chat over a sandwich, and he was delightful. I still have my Holloway Prison mug, made by prisoners through a charity. Sadly, Lord Parmoor has passed on his mug, and the tea towel, no doubt, too. But I'm very much aware of his huge enthusiasm and generous support for the work of the League. You could say that prisoners and coroners have something in common. They are both locked away in their own little worlds, in their own particular corners of the administration of justice. Many coroners have said to me that they feel isolated, not unwanted and unloved exactly, but operating on their own under variable local conditions. And it is that localness which has produced a lack of consistency in their work, perhaps the greatest criticism levelled against coroners, one of which coroners are aware of, and I believe are prepared to put right with a little bit of help. Although individual coroners are part of a national structure of coroners, part of a statutory framework of coroner services across England and Wales under the Coroners Act of 1988, it is a service which operates very locally. Each coroner is appointed locally by the local authority, paid locally, and their service is funded locally. Within that local structure, coroners are required to operate independently, acting as judicial officers in their coroner work, making judicial decisions, investigating deaths, deciding whether a death is from natural causes or not, presiding over inquests in their court. They are best described as independent judicial office holders, although in the case of Forrest, they were described as judges. And this interface between the independent judge side of the coroner's work and hard-pressed local authorities who fund the service, provide accommodation, pay for the coroner and staff to support the coroner, pay the medical bills such as post-mortem examinations and toxicology, is not without its difficulties. Not all local authorities fully understand this central element of judicial independence. After all, they say, we are paying the bill, it's our public money we're spending, so some want coroners to be brought more into the local authority fold, to be like chief officers. But coroners are not chief officers. They are not council employees, so being local is not always easy, particularly in hard financial times. I was in Wales yesterday, and an excellent coroner told me what happened when she first arrived. Her letters to the chief executive and her telephone calls were ignored, and when finally she was sent a minion lower down the scale, she said, I want to provide a gold service here in Cardiff. And he said, you'll get a basic service from us, love, and that's it. And that was it. That's what she got. So the question I want to pose tonight and try and answer is this. What is the purpose of a coroner system in the 21st century? Whether local or national or a bit of both, what is the justification for a coroner system? Why do we have one? It may help to understand the role of the coroner today by looking briefly at the coroner of yesterday. The origins of the modern coroner system despite being ancient, are surprisingly not obscure. Since coroners were originally keepers of records, there are records which coroners kept. They tell us what coroners did. There have certainly been coroners for at least 800 years, although not a chief coroner until now. Nearly 130 years after the Battle of Hastings and the arrival of William as the first Norman king, Article 20 of the Articles of Eyre declared that coroners were, in September of 1194, and that's pretty precise, the custodians of the pleas of the crown. Of course, it was all about money. Nothing changes. The English king at the time was Richard the Lionheart. He was not only a foreigner, a Norman who lived in France, although born in Oxford, he was a warmongering foreigner. Modern tales of Robin Hood have a lot to answer for. Richard was not the benevolent, kindly king, much missed and longed for by long-suffering serfs. On the contrary, he disliked England, rarely visited, and bled the Saxon England dry of money to pay for his extravagant crusades. And when he holed up in a pub in Vienna, on his way home to France, having been shipwrecked off Italy, he was recognized and held ransom for an enormous sum, which, of course, the English Saxons had to pay. A bit like the Germans bailing out the Greeks, all in the interests of some kind of European stability. But perhaps that's a bit unkind. So money had to be collected, and the office of coroner developed as something of a cross between a stipendiary magistrate and a collector of fines, also making sure the sheriffs did not cheat the king. The proper judges, known as the general heir, rather like the itinerant assize judges much later, came round to levy justice and fines. But there were no virgin trains then, so they only got round every few years, sometimes only every 7 years. In the meantime, the coroner, who was at first a knight of the realm, would keep the records of all the local misdemeanours, the pleas of the crown, and hand them over when the judges rode into town. Custos placitorum coronus, hence crowner or coroner. I won't run the Latin past the Prime Minister. He probably thinks carpe diem is fish of the day. Local rules then got rather complicated, so if you broke a rule, you had to pay a fine, no less than with dead bodies. A myriad of fines and penalties grew up for violent deaths and suicide, for failing to prove that the body was Saxon and therefore not Norman, a murdrum fine, fines for an unclaimed body, for burial before the coroner arrived, anything to enrich the royal coffers. Dead bodies meant cash, for the crown at least. And it was in this context that the medieval coroner investigated deaths, holding inquests with local jurors who had to inspect the body. He also took confessions from criminals and kept the records. He supervised abjurations of the realm, a kind of voluntary deportation of murderers. They sought sanctuary, the coroner took their confession, then they were given a route for leaving the country to escape punishment, often execution, and a deadline for leaving the country. It did not always work out too well for the criminal. For example, malicious coroners in Yorkshire ordered criminals to leave the country, not by the quickest route from Whitby or Harrogate, but by Dover. And of course, most never made it. They were either killed on the way or starved to death. And Mr. Grayling, please don't get any ideas about that. So for a long time, the ambit of the coroner's work was homicide, suicide, infanticide, all manner of unnatural deaths. For a while in the 13th and 14th centuries, only homicide concerned the coroner. That did not stop some coroners from extracting bribes from bereaved families so that burial could be allowed to take place. By the 15th century, the office of coroner was almost obsolete, but not quite. The coroner became active again with the Coroner's Act of 1509 in the first year of Henry VIII's reign. I'm hoping that a doughty coroner will feature in the next instalment from Hilary Mantel. writer in residence at Hampton Court, a coroner had then to view the body of someone slain, drowned, or otherwise dead by misadventure. The coroner himself would be fined if he did not. And so we leap with undue haste to the 18th century. By then, if not before, some coroners took bribes to avoid investigating suspicious deaths. So the Coroner's Act of 1751 provided for the better ordering of the office of coroner, including proper payment to coroners for inquests, if duly held, and if approved by judges at the local court of sessions. By 1829, the first edition of the standard textbook for coroners, still the standard textbook, Jarvis on Coroners, was far from positive in its assessment of coroners. The preface of John Jarvis begins with these words: that the office of coroner is of great antiquity and was originally of high dignity, all writers agree. And you feel a but coming. But the office, whether in consequence of the rust and relaxation inseparable from ancient institutions, or of the inefficiency of its officers, has fallen from its pristine dignity into the hands of those who are in some instances incompetent to the discharge of even their present limited authority. Never mind. Onward. In the 19th century, the demand grew for sensible information from coroners about the causes of death. This led to the proper registration of deaths under the Births and Deaths Registration Act of 1836. Bureaucracy caught up. The fine for burying a body without the appropriate certificate was up to £10. The Coroner's Act of the same year pushed the system towards medical authenticity by authorizing payment to medical witnesses for the first time, although the qualification for coroners was still only to be a freeholder. Dr. Thomas Wakeley, who was the founder of the Lancet in 1823, was the first coroner to be medically qualified when he took up his appointment in Middlesex in 1839. 174 years later, next year, in 2013, new appointments of coroners will no longer include doctors who are not legally trained, and there are very few doctor-only coroners left today. So by Victorian times, the role of coroner as crown money collector was long gone. The modern coroner system was taking shape with the twin aims of the need to detect homicide and the provision of health data for the control of injury and disease, but only where the death was unnatural. J.J. Dempsey's call in 1859 for coroners to become chief officers of health went unheeded. The 1887 Act became the basis for modern coroner law, now framed in the Coroner's Act of 1988 and the Coroner's Rules of 1984. The Local Government Act of 1888 finally abolished the election of coroners. They were to be appointed by local authorities. In more recent times, the second half of the 20th century was not short on changes and proposals for reform. It was not until the 1970s, for example, that coroners no longer had to view the body, and juries were stopped from adding riders to their verdicts. No more could an inquest name and commit for trial a person believed to be guilty of murder or manslaughter. The last such person was Lord Lucan in November 1974, who was committed for trial in his absence at the inquest into the brutal death of his nanny Sandra Rivet. Since then, there have been three major reports on death certification and coroners: the Broderick Committee report in 1971, the Luce Review in 2003, and Dame Janet Smith's Shipman reports in 2003 also. But one recommended change, a fundamental change, has not been made. Both Luce and Smith, and to a lesser degree Broderick, called for a national coroner service. Not just a national framework as at present, but a national scheme, a coroner-judge scheme, paid for and run by what would now be the Ministry of Justice, like other judges. This has not happened. Hence the continuing local nature of the coroner jurisdiction and the feeling, as I said, that some coroners have of isolation. Since those 3 reports, there have also been government papers on reforming the coroner and death certification service and much consultation, all leading eventually to the Coroners and Justice Act 2009, passed broadly with all party support. It produced the chief coroner, the only part, with one exception, of the Act which is in force. The rest is expected to be implemented in June of next year. It is not a radical act of Parliament, perhaps because it was passed with broadly all-party support. It does not make sweeping changes. It does not create, as Luce recommended, a unified national coroner jurisdiction for the chief coroner to oversee. It does not create, as Janet Smith recommended, a centrally governed national service led by a chief judicial coroner, a chief medical coroner, and a chief coroner's investigator. But there are some good changes, and the move is in the right direction. There will be greater flexibility within the coroner system, replacing to some extent the rigid jurisdictional concept of coroner territoriality. Some coroner areas will be amalgamated to produce consistency of coroner area size, each area with a full-time coroner. Appointments will be scrutinized by the chief coroner. Coroners will no longer be able to appoint and discipline their spouses or partners. There will be, for the first time, compulsory training under the auspices of the Judicial College, which trains judges, and not just for coroners, but for coroners' officers too. The emphasis of the Act will be upon the whole investigation and not just the inquest. There will be a more coordinated complaints system. In short, the new Act will move steadily forwards towards a more integrated system, more flexible, more alive to the needs of the bereaved, more open and transparent. And there is a chief coroner to lead the coroner service. But there nearly was no chief coroner at all. After an open competition, I was appointed chief coroner by the Lord Chief Justice after consultation with the Lord Chancellor, as the Act requires. But I received my letter of appointment on the 6th of May 2010, and that's the date of the general election. That was not an auspicious day for appointments. The coalition government was not keen on having a chief coroner. In difficult times it was considered to be too expensive. Civil servants came to see me with gloomy faces, and I was very politely told to keep up the day job with the Old Bailey. It's not often you get an apology in person from the Lord Chief Justice and the Lord Chancellor 2 days running. They were really very nice about it. So the Chief Coroner and all his powers was placed ignominiously into Schedule 1 of the Public Bodies Bill, commonly known as the Bonfire of the Quangos, for abolition. The House of Lords, in their amending and revising role, led by the impressive Baroness Finlay, a doctor, Dr. Finlay, and Professor of Palliative Medicine, voted by a very large majority to keep the Chief Coroner off the funeral pyre. But the government remained unimpressed, and in December 2011, the Public Bodies Bill was due to become law. Meanwhile, I'd been appointed to conduct the inquest into the death of Ian Tomlinson, who died during the G20 protests in the City of London in 2009. It was my first experience of the loneliness of the long-distance coroner. However, the final twist in the Chief Coroner's tale came last year. At first, it was decided that the Chief Coroner's powers would be shared between Lord Chief Justice and Lord Chancellor, but eventually in November of last year, the post of Chief Coroner was reprieved. I have not been told why that decision was made. There was certainly a lot of lobbying before it was made by the Royal British Legion and other groups about service deaths, military deaths, but I do not propose to speculate. There was, however, one major casualty. The Chief Coroner's appellate powers to hear appeals from coroner and inquest decisions would not be implemented. they were specifically repealed in the Public Bodies Act. But nevertheless, there is now a Chief Coroner for England and Wales. I took my appointment last month. I'm hoping that coroners will be more generous about me than Alan Michael, MP, former minister, was in the passage of the Coroners and Justice Bill, when he said, considering the administrative side of the Chief Coroner's role, the Chief Coroner is a judge, so he's not necessarily competent to run anything. I make no comment about that. I am a judge sitting at the Old Bailey, and perhaps in my defence I could say that Norman Broderick of the Broderick Committee, which reported in 1971, was also a judge of the Old Bailey. And as part of my new role, I have been out and about, visiting coroners, coroners' officers, in their courts, in their offices, seeing all manner of inquests, speaking to institutions, groups, lobbying groups, campaigners, all sorts. And I was being very kindly driven from Bolton to Liverpool one day when we passed the turning off the motorway to Knotty Ash. Only one person comes to mind when one mentions Knotty Ash, Ken Dodd. For younger listeners and viewers, he is a rather eccentric-looking comedian from Liverpool with a mop of electric hair and prominent buck teeth. Anyway, I thought of the young journalist who was said to have gone north to Scotland on a project to see a Scottish Member of Parliament. Waiting in a room for the MP, the journalist saw a photograph of Ken Dodd on the wall. And when the MP came in, thinking of something to break the ice, the journalist said, "I see you're an admirer of Ken Dodd." There was a moment's pause before the MP said, "That is not Ken Dodd. That is my wife." I'm sure the interview went very well. Well, it is my purpose as Chief Coroner to provide leadership for the coroner system, to oversee the implementation of the 2009 Act, to develop reform, to create a more coordinated and accountable system, all with a national consistency of standards and approach. No pressure then. Tom Luce, in his review of the coroner system in 2003, described coroners as the forgotten service. Not anymore, I can assure you. In my first speech last month to coroners at the Coroners Society Annual Conference, I set out my 10-point plan. I will not repeat that tonight. As I turn over the page from the 10 points, I found another 25 behind that. Turn over anyway. So there's much to do, short-term and long-term. But I welcome the challenge. There are many excellent coroners out there. They work hard, they are dedicated and committed to the service, they perform their duties with sensitivity and understanding, and they have first-class coroners' officers. But they have also said to me, "I do this my way. I may be right, I may be wrong, but if you tell me to do it differently, I will." So I shall be happy to work with coroners in the development of a good, consistent coroner service. So what then is the purpose of this 21st century coroner system? The Broderick Report expressed the opinion in 1971 that not many coroners appear to have a clear idea of their role in contemporary society. 20 years later, in 1994, an article in The Lancet concluded that the coroner system was suffering from the absence of a clear purpose. Tom Luce's review team concluded that there were no agreed objectives or priorities. In the third Shipman report, you remember that Harold Shipman was convicted in the year 2000 of 15 murders, but it is thought that he killed over 200 people over a 20-year period. Dame Janet Smith expressed the view that neither the current Act nor the current rules provided much in the way of establishing the purpose of an inquest. In 2006, the Coroners Society complained of the lack of a clearly defined purpose for the coroner service. Neither the present Act nor the next one states a purpose for the coroner system. So I must provide my own answer, a provisional answer, because this is a chief coroner at the beginning of his tenure. Before I venture my answer, I just want to put the question into a modern day statistical context. In England and Wales, that is the limit of my remit, there are just under 500,000 deaths a year, quite a steady figure. For comparison, there are about 700,000 births a year, quite a surprising difference. Over 60% of all deaths in the country are from circulatory diseases or cancer, about half and half. The next highest category is respiratory disease at 14%. Of the 500,000 deaths each year, just under half, some 220,000, are reported to coroners. About half of those deaths, some 93,000, will undergo post-mortem examinations by pathologists. That figure is too high, and I will try and reduce it. Only 1/3 of those, some 30,000 deaths, will lead to inquests, just some 450 with juries. So who deals with these 220,000 deaths reported to the coroner's office locally each year? There are just under 100 full-time coroners, assisted by over 300 part-timers, all fully qualified to investigate deaths and conduct inquests in their local area. As I said, they are independent judicial office holders, appointed and paid, but not employed by the local authority. In essence, the coroner has a duty to hold an inquest where there is reasonable cause to suspect that the deceased has died a violent or unnatural death, a sudden death of unknown cause, or has died in prison or custody. In each case, the coroner must find the answers to 4 questions about the death. Who was the deceased? Where, when, and how did the deceased die? How? That important word is interpreted not as how in a very broad sense, which would involve general and far-reaching issues, but as by what means, and sometimes, particularly in death in custody cases, by what means and in what circumstances, slightly wider. So the emphasis for the coroner is upon the how. How did the deceased come by his or her death? This is the statutory context of the coroner's jurisdiction, as interpreted by the higher courts. So then, bearing in mind the history of the coroner, the development of the coroner's role, the statistical context and the statutory framework I have just summarized, the question I posed was, what is the purpose of a 21st century coroner system? In my view, the purpose of the coroner system today is to provide justice to the public in 2 ways. First, the public, especially the bereaved family, need to know what happened, how the deceased came by his death. That applies particularly to deaths in custody or at the hands of an agent of the state, where there is a wider duty to protect citizens from the wayward or mistaken actions of the state and to expose wrongdoing and bad practice. But it applies equally to all deaths where there is a real element of uncertainty. The public need to know. They have a right to know. It is natural justice, public justice, and justice to be done in public, openly and transparently, for all to see, particularly the family. The family has now become, quite rightly, the focus for this public process, to give them answers where that is possible. They are at the heart of the process, as the Charter for Coroner Services makes clear. It is not a question of laying blame or apportioning guilt, either civil or criminal. That is expressly forbidden by law in the inquest process. The investigation and inquest process is inquisitorial, with a view to seeking out and recording as many facts concerning the death as the public interest requires. It is a fact-finding exercise and not a method of apportioning guilt. That is not to say that the process cannot find fault in someone or something. It can and must where something has gone wrong which led directly to the death or contributed to it, as with hospital or care home neglect, but by way of findings of fact, not judgmental opinion. As Lord Bingham said in the leading case of Jameson, the coroner has a duty to conduct a full, fair and fearless investigation, and the coroner does so as an independent judicial officer, with powers to summon witnesses and jurors and hear evidence under oath. The verdict of the coroner or the jury can be in a short form, such as unlawful killing, or suicide, or accident, or it can be expressed in a brief, neutral, factual statement, expressing no judgment or opinion. This is called a narrative verdict. There may be a short-form verdict, a narrative verdict, or both. For example, in the Ian Tomlinson inquest, which I conducted as coroner, the short-form verdict was unlawful killing, but there was also a narrative of the facts as the jury found them. A single page, carefully considered, carefully written out, explaining the jury's essential findings of fact on key points, answering questions such as where the deceased was going, what he was doing, whether he was complying with police instructions, how he was pushed by a police officer, whether the force was excessive and unreasonable, what injuries he suffered, and whether his injuries resulted from that use of force. Single sheet of paper, signed by all 11. The law requires the jury to be 7 to 11 in number, not the magic 12. It is true that there is quite a list of investigating organisations, such as the Independent Police Complaints Commission, the Prisons and Probation Ombudsman, the Health and Safety Executive, the local Safeguarding Children Board, to name but a few, all doing the job of investigation independently. But often their reports, their findings, are for one reason or another not made public. This is where the inquest provides the necessary public forum, in a public court, in open court, where the media can attend if they want to, with evidence under oath. Public justice done publicly. The second way in which the system provides justice to the public is this. The coroner system exists to provide justice to the public, not only in identifying causes of death, but in preventing future deaths of a similar nature, something which families often feel passionately about. They say, and rightly say, our beloved should not have died in these circumstances, and what is more, we do not want his death to be in vain. We do not want it to happen to anyone else in that same way. Coroners are under a duty, and one which I shall emphasise, to report to government and local government and agencies and institutions so that lessons can be learnt for the future. For example, in identifying a defect in railway crossings, or a systemic failure in custody treatment in prisons or police stations, or a lack of warning signs against a special danger, or inadequate post-operative care in a hospital. These are just a few examples which can lead to changes for the better to avoid future similar deaths. And I've been on the course, the Ministry of Defence course for coroners who conduct service death inquests at Warminster, where they show you over a period of 2 days the various equipment that soldiers carry, the procedures that are carried out, and so on. And from time to time, a senior officer would say, well, we now use that equipment and not that anymore because a coroner made a recommendation in an inquest. We now have changed that procedure, that process, because a coroner made a recommendation. There may be other answers to the question which I have posed, not least being the recent developing duty of coroners in Article 2 inquests. Article 2 of the European Convention on Human Rights provides that everyone's right to life shall be protected by law. Where somebody dies at the hands of the state, or somebody dies, particularly somebody vulnerable, in custody or detention, or otherwise in the care of the state is likely to have a duty to initiate an effective public and independent investigation. This procedural duty, as it is known, is carried out either by full criminal proceedings, or if there are none, by a full coroner's inquest, known as a Middleton inquest. This is an important responsibility for coroners, and I would argue an essential part of public justice. On the other hand, there are those who believe that coroner practice should be more medically focused. Catherine McGowan, in her excellent recent doctoral thesis on coroners, argues with some force that in the absence of a clearly stated statutory objective, the fundamental purpose of the coroner should be as facilitator of public health, with the coroner system taken in under the wing of the Department of Health. After all, she argues, some coroner systems inherited by common law countries have tended to move away from the legal coroner to the medical examiner system. And that is true to some extent in the United States and in Canada. Under our present law, coroners, as I've said, are lawyers or doctors or both, although there are not many coroner doctors, doctor-only coroners left. The new Act coming into force next year will require all new coroners to be lawyers and have the same legal judicial qualifications as judges. I see that as a good thing. There is a good case for coroners being more judges than guardians of public health, although both are important. It is true that much of the coroner's work is out of court, and even in court there are many straightforward short inquests. Some coroners complete as many as 6 or 8 in a day, without minimizing the importance to the bereaved family of the process of inquiry. I have seen that for myself. But there is also a growing number of complex inquests taking days or weeks. Local authority payments to part-time coroners still refer to a long inquest as one lasting more than 1 day. Unfortunately, not anymore. These inquests may involve difficult issues, tough points of law, questions of admissibility of evidence, public interest immunity, careful directions to a jury, alternative verdicts, and much more. Inquests of that kind often involve lawyers representing interested persons. A lawyer coroner may be better equipped in that sort of forum. Expert medical opinion will provide the necessary medical expertise. Rule 43, the rule empowering coroners to report and make recommendations, was amended in 2008 to give greater prominence and importance to coroner reports to improve public health and safety. So for me, at the beginning of my tenure, the balance between law and medicine is moving in the right direction. So that is my assessment of the purpose of the modern inquest system. But not all coroner cases go well. Finding justice is not always easy. You will all have heard of the controversial case in Australia about the baby and the dingo. It took 32 years and 4 inquests before the coroner of the Northern Territory in Australia came to the conclusion that the 9-week-old Azaria Chamberlain had been taken from her parents at Uluru, Ayers Rock, by a dingo. Evidence had been collected that dingoes had attacked and killed before. Meanwhile, Lindy Chamberlain, now Chamberlain Crichton, had served 6 years in prison for killing her child. The case against her had been based upon the evidence that the body was never found and that traces of blood were discovered in her car. Those traces turned out years later, with the development of scientific techniques, not to be blood at all. The coroner at the 4th and final inquest in June this year found that a dingo or dingoes were responsible for the death. The death certificate was amended from unknown to attacked and taken by a dingo. The father of Azaria, Michael Chamberlain, said this: "I'm here to tell you that you can get justice even when you think that all is lost, but truth must be on your side. I cannot stress strongly enough how important it is to pursue a just cause even when it seems to be a mission impossible." And that is what all families want, to get justice. Not just the parents of children, although they are almost always the most distressing of cases, but all families who lose a loved one. The 4 questions, who, when, where, and how, will be answered in most cases. In a few cases, the answers will remain incomplete, sometimes for a long time, even forever. But it is always the duty of the coroner to do his or her best to obtain that justice for the family. That is what families want. That is what they are entitled to. Public justice for the public. Finally, I would like to end with a story about the Howard League. My last case as a barrister, when I was at Doughty Street Chambers before I became a judge at the Old Bailey, was pro bono in the North Avon Magistrates' Court near Bristol. I could not recommend the B&B where I stayed nearby, where the inmates all took turn to use the microwave for dinner with the freeze-packed curries which we had bought from Morrison's across the road. My client was Pauline Campbell, a fellow trustee at the Howard League, who was charged with obstruction of the highway. Pauline's daughter, Sarah, had had a troubled life. Her father had left home when she was very young, she was raped as a teenager, and she took to drugs. One day, she was begging in the street for money for drugs, and an elderly man refused. She pushed him away, and he fell over and had a heart attack. He died, and she was convicted of manslaughter and sent to prison, HMP style. On her first night there, Sarah took her own life. She was 18. The staff had declined her request to be put in a vulnerable prisoners unit. The jury at her inquest decided that the prison had failed in its duty of care to her. I would add in parenthesis that unfortunately the recommendation in the Corston report in 2007 for the closure of women's prisons and their replacement with small local custodial centres has never been implemented. Pauline, of course, never recovered from her terrible loss, the loss of her child. A friend of Pauline said of her, "I had a sense of a woman who would be wailing in pain if she was not able to keep herself busy." Pauline kept herself busy by becoming an ardent campaigner for young women in prison. She turned her tragedy into positive action. Each time a young person committed suicide, she went to the prison, outside, and protested. She stood in front of any prison van arriving with customers and asked the driver to take them to a safer place. Pauline, an intelligent woman, a lecturer, made good with her protest, bringing the local media to film her and to give interviews, arguing her cause, giving publicity to her concerns. It was effective. But she was arrested in different parts of the country, as you might expect, 14 times, in fact. She was charged 3 times out of those 14, but only one case was brought to court, in the North Avon Magistrates' Court. There we were. The television crew was outside. Pauline was smartly dressed. The rather ragged group of supporters came too and had to be shushed in court by the magistrate. I pretended to glare at them. And the prosecutor had certainly missed out on charm school. But Pauline gave a good account of herself, and there were a few technical arguments which might have helped. Arguably, she was not on the highway at the key moment, but on a private road. She was acquitted. A few months later, shortly after another of Pauline's protests at Stile, where her daughter Sarah had died, Pauline gave up the struggle. She was found dead in the cemetery where her daughter was buried. She took her own life with an overdose of antidepressants. The coroner at her inquest described her as a significant campaigner in the cause of prison reform, like the Howard League itself. This sad tale reminds us of the fragility of life, the need for compassion and understanding, and the provision of a system of fair justice for everybody in life and in death. I hope that coroners will bring these qualities to their daily work. I shall do my best to make sure that they do.
Peter had warned me he was going to talk about Pauline, but that was really moving, and I'm quite choked up, so excuse me. I mean, she was a trustee for many years, and we worked very closely with her. And my daughter's called Sarah as well, as the same age as Pauline's daughter, so we had a close bond. That was incredibly interesting and very stimulating. And we have got a few. Do we have roving mics? We do. We have waving over there. So if there are questions, please could you identify who you are and speak clearly. And if you don't have, I've got questions. Yes, we have in the front, in the middle. Man there, thank you.
Thank you. My name's Chris Hammington, and I'm a recently joined member of the Howard League, for which I should be ashamed, because I should have joined years ago. Just one question to His Honour, and that is and a word of thanks, because he can take all the plaudits. It probably has nothing to do with him whatsoever. But very recently, in the last week or so, the coroner has determined that he will proceed on the Mark Duggan inquest. And I come from Haringey. I've been involved in the community in Haringey for a very long time. We have suffered a number of deaths in circumstances which have caused considerable angst within the community, from Cynthia Jarrett through Roger Sylvester down now to Mark Duggan. And one of the things that worries me most, and I'd like to know what his view is that coroner's courts can be very, very delayed. They can take years and years to even commence. I understand that they're complex cases. Very often these are difficult cases in public terms as well. But would he agree that justice delayed is justice denied? And would he be able to use his influence to try to ensure that inquests are held speedily and effectively, rather than, at times, it seems, delayed for administrative convenience of some?
Yes, thank you very much. I won't say anything about the individual case, because I shall not in any way interfere in the process conducted by the independent judicial office holder, the coroner. But I do agree that justice delayed is justice denied. The new Act, the Coroners and Justice Act of 2009, says that rather indirectly by suggesting that every case, every investigation which does not have a conclusion within 1 year should be reported to the Chief Coroner. And underlying that is clearly that reasons should be given for that delay, and if not, the Chief Coroner should try and do something about it. There are long delays sometimes where it's not the fault of the coroner. I emphasize that. There may be a very long investigation. The IPCC could take a long time, the health, and then there could be criminal proceedings. The Health and Safety Executive could take even longer, and then there could be criminal proceedings. So that could take you beyond 2 years. But in many cases there is no need for a long delay. There are certainly some backlogs in some areas, and I shall be working to try and reduce those wherever they appear. But delays should go and should only be of a reasonable length.
Thank you. Gentleman here and a lady there. So we'll take the two together because I'm lady in the middle, like. Thank you.
I'm Colin Berry. I was a member, or a pathologist, a member of Tom Lucy's inquiry. You made the point that you thought that rather too many autopsies were done, and I agree with you, having done some thousands myself. But I missed from the recommendations that we made the role of the medical examiner. What does worry me is that by deciding to do less autopsies, will you decide, or will someone decide, to do the wrong ones or not to do the right ones, if you see.
And the lady there, do you want to? Yes, yes.
Thank you. Karen Robinson from the charity Missing People. We are campaigning for better procedures in the cross-matching of unidentified bodies with missing person inquiries. And I just wondered if you could share your vision for if you plan to standardise procedures around how better cross-matching procedures will be followed so that people with a loved one missing can get some reconciliation if their loved one is found in a different police force area than where they've reported them missing.
Yes, well, I spoke for slightly longer than my allotted time so that I could reduce the number of questions like that I would get. But thank you. I'm not yet an expert on cross-matching procedures, but I know how important they are, and identification can be very important, and mistakes have been made in the past. You can have deaths abroad, a number of deaths, say from an air crash, and the coffins come back misidentified. So it's very, very important that there is fresh identification coming back into this country. But that's probably not an answer to your question. I'm sorry about that. Coming back to you, sir, the pathologist who was on the loose review team. Yes, I want to reduce post-mortem examinations. That we, as you will know, and many may here know, we have more post-mortem examinations of the type which is sometimes described as invasive than any other common law country which has a similar coroner system. We are twice or three times as high, or higher, than some other countries. Why that is not entirely clear. But, for example, there is sometimes a lack of confidence. I don't think it's anything to do with the Shipman effect, but that's always lurking in the back. But there is a lack of confidence by doctors or by coroners in saying, all right, here is a 95-year-old woman who has died peacefully in her bed. It looks as though it's a stroke or a heart attack. She's not had medical problems for some time, but she hasn't seen her doctor for 14 days. Therefore, there has to be a post-mortem. We've got to be sure, one way or another. And that seems to me to be unnecessary. You touched upon medical examiners, which is sometimes called the death certification scheme, which is in its pilot stages at this moment and is due to come into force in April of 2014, whereby the doctor, the GP, who is giving a cause of death will be supported or checked by a local medical examiner. Now, this is quite a controversial scheme, it seems to me, on the ground. And what worries me at the moment is that in the pilot studies, there is an increase in post-mortems as a result of the scheme, about 9 or 10%. There may be an increase in the number of inquests of as much as up to 30%. So that's an additional caseload for coroners which they cannot at the moment bear. There's no money locally. Local authorities are reducing their money for the coroner's service. They are putting everything out to tender, the toxicology system. Probably the pathologists soon will be put out to tender, if there were enough of them. But that's the best answer I can do for your question. Thank you.
I will take 2 more quick ones, and that's it. Alex, over here. So one over there, one over here.
Alex Carlisle, barrister. Can I ask if you're satisfied with the way in which evidence that has the potential for damaging national security is dealt with at inquests, and whether you will have any advice to give to coroners as to how to deal with such evidence?
And lady here.
I'm not sure. Is this on?
Yes, it is.
Yes, I'm Pamela Peskett, retired but very heavily involved in youth justice. But I just, because I'm not used to the subject, I may be asking rather a silly question. However, you did say that you felt that a coroner's work should be fact-finding but not apportioning guilt and not judgmental. So why is there a jury? Because surely the jury would come after the criminal case. I mean, do such cases have to have 2 trials by jury?
Sometimes. It is a fact-finding process, not apportioning blame or guilt, because that's what the law says. Rightly or wrongly, that's what the statute says, the Act of Parliament, and that will not be changed when the new Act of Parliament comes into force next year. But you can have, as there was in the Tomlinson inquest, don't want to go into the details, but there was a full inquiry. The Director of Public Prosecutions had decided not to prosecute the police officer in question. There was only one police officer in question, could only have been one. But he said that he would consider afresh if there was evidence at the inquest which might change his mind. The jury came to a verdict of unlawful killing on the basis of findings of fact. That does look a bit judgmental, I know. It does look a bit like an opinion. But that person is not named, but those are their findings of fact. There may have been no criminal proceedings at all. The Director of Public Prosecutions might have said, well, I'm not changing my mind. In fact, he did change his mind, and there were criminal proceedings, so there were 2 juries. But that's pretty unusual. Alex, your question about security, which is difficult. The question of, for example, covert surveillance, which raises its head from time to time, not very often, but occasionally, is very difficult for coroners, because the REPA Act, as it's called, I can never remember what its full title is, everybody calls it REPA, puts restrictions, or appears to put restrictions, there again there is some dispute about this, on what evidence the coroner is entitled to hear. Is he a judge for the purposes of REPA proceedings? Are these proceedings which the Act covers at all? Or does there have to be a judge who sits at the inquest, who is qualified? Or does there have to be a public inquiry? My advice to coroners at the moment is to tread carefully and get good independent legal advice, because this is a bit of a minefield. One way round it would be to have the confidence of Parliament to extend the powers of the judge and the scope of proceedings to inquests and coroners, so that a coroner would be able to say, as Lady Justice Heather Hallett did in the 7-7 inquest, as a judge of course, I can look at this material, I can make observations about it without releasing it into the public domain. Coroners might be able to do that as well if the Act was amended, and there might be some force in that. But that is really being considered quite widely at the moment.
Thank you, Peter. I mean, that's absolutely fascinating, and we will watch with great interest, and I hope you get the resources to do your job. because that's going to be the critical question, I think. We will put a copy of your speech on our website?
Yes.
Yes, we will. We will put a copy of your speech because I think I'd like to have another look at it. I'm a medievalist by training, not a lawyer, so I like the early stuff as well. You are very welcome to stay now, thanks to Clifford Chance, who very generously gave us this venue and are going to give you lovely drinks and lovely little eaty things, very high quality eaty things. So you're very welcome to stay and mingle and talk to each other and talk to my staff and, of course, join the Howard League if you're not already a member and haven't already been a member for many, many years. Thank you very much.